afternoon and welcome to the Law and Crime Network. I'm Angelica Spanos. Thanks for joining us this afternoon. Okay, so court there just went into a sidebar. I want to mention that we have 3 experts joining us today to break this all down. Joining me in studio is Thomas Leotti. Thomas, thank you for joining us today. And also we have Matt Mangino, a law and crime legal analyst, also here, and Andrew Cherkasky, who is also joining us via Skype. Hey, guys.
Hey, how are you?
Great. So talk about what we've seen so far. Obviously, this is still unfolding here. But first off, Thomas, what do you think of the prosecution rebuttal right now?
Well, you know, this is a very, very difficult case for anybody when you're talking about 3 dead bodies at the scene and so on. This is very, very difficult for a defense to overcome because the sheer gore of that, the sheer magnitude of that is just highly, highly prejudicial here. And that may be one of the reasons why this was a relatively short trial. But you've got, you know, a death-prone state, a death-prone jury, a death-prone judge, a death-prone prosecution. And what you're really trying to do is to not only challenge the intent issue, but you're basically trying to get, as a defense, something that defense lawyers can't really talk about or ask the jury to do, but you're asking them to nullify the statute and decide essentially that the statute is unfair and unconstitutional. So of course you can't legally say jurors nullify this case and don't follow the law because they're obligated to follow the law. But we know if they follow the law, in all likelihood, since this is a death-prone state and the law definitely favors death, that they're likely, after a conviction that they've already given on capital murder, that they're likely to sentence him to death.
All right, Thomas, thank you. Matt Mangino, what do you think of the closing argument so far? I know this morning we heard from the prosecution and Jill Richstone, who I thought did great.
Well, I think that, you know, it's important that the prosecution, as they did this morning, you know, lay out methodically the evidence in this case. Obviously, the evidence, you know, statements by the defendant and the sheer volume of physical evidence, you know, clearly establishes the guilt. And now the issue ultimately will be whether or not the death penalty should be imposed. And again, you have 3 victims, you know, which makes this a case that's certainly difficult for the prosecution, I mean, difficult for the defense. But the defense, you know, has an obligation and a responsibility to put as much mitigating evidence out there as possible to try to save their client from the ultimate punishment. And I think that's what the defense has to do here and will continue to do.
All right. And Andrew, what about you?
I think what we're talking about here is the concept of litigate to mitigate, which means that the defense in this case kind of came forward with maybe there was a framing going on. There's all these little things that they're kind of coming at, really given the nature of the drugs and the guns and everybody involved in that. And what ultimately you get at is not a particularly strong defense. The prosecution in the rebuttal has to come back real strong, and that's what they're doing right now. And what the defense is hoping for is even if there's a conviction, there's still some sort of sympathy there, given kind of the chaotic nature of who these people are.
All right, Andrew, thank you. Well, you mentioned that prosecution rebuttal. Let's go back to that courtroom live and listen to it here. Okay, so the prosecution's rebuttal argument is finished. She said that she asked the jury to find him guilty. She listed all the accounts and charges. She said that he went there with the intent to kill, that there was no doubt. Andrew, let's talk to you about this. What's your initial reaction to that?
I thought it was a great rebuttal argument. It's exactly what we teach young law school students. When you give a rebuttal, it's not to go back to some closing argument that you pre-wrote. It's to specifically rebut, but you do it with the best strategy you can without specifically crediting or bringing back up the words of the defense counsel. So you kind of imply it, but then you get right into your argument about how it's what your defense is or what the rebuttal is to the defense's argument. And she did just a fantastic job of that, I thought.
Yeah, one of the things that stuck out to me was when she was describing Vorpagel running for his life, and she talked about the, the bullet path and all of that. That was really interesting to me.
Oh, absolutely. I mean, she talks about that. She talks about the idea that there's this implication that maybe he wasn't the actual trigger man. There's the idea that the premeditation may not have been particularized before arriving. She's really hitting on all these different elements that the defense, if they're really going for the jury nullification type of thing, she's getting right at it, and she's doing a nice job of disassembling the defense's closing argument.
All right, Andrew, thank you. Another thing we were talking about here on set with Thomas here is how she was referencing the instructions that the jury will get. Why'd she do that, and what's her thinking there?
Yeah, I think that's very improper, frankly, because her function is to talk about the evidence in the case. In a rebuttal or whatever she may be doing, she's supposed to just concentrate on the facts. It's the judge's province to address legal questions and the law. So when she started talking about the law, this becomes a problem and should have been objected to and should have been sustained by the judge. This is a judge who's already found the Florida statute to be constitutional. Now, she's got an interesting argument here that she's made on what's called transferred intent. So while the state's case may be weak as to the defendant, by grouping him with everyone else, all the other actors and so forth, it then becomes a case of transferred intent. There's an old common law case, Talmadge versus Smith. So Talmadge was hit with a rock, and it was thrown by Smith. And Smith meant to throw the rock to or against somebody else, but it hit Talmadge. And Talmadge was able to make an argument of transferred intent and therefore won a civil verdict in that case. This, of course, is a criminal case where you can't really have transferred intent. Intent is the operation of someone's mind on a particular incident, and you can't establish that by transferring it and establishing it through someone else's intent.
All right, well, that's a much easier way to understand it. What do you think of her rebuttal in general, aside from that?
Well, here's the thing. Maybe I'm going to say something that's a little bit controversial here, but here is an African-American woman who was very, very sharp and very, very good in her function. But I have to be thinking to myself, as maybe a white defense lawyer, thinking, here's an African-American woman who is vouching for the morality and ethics of a statute which has been applied almost universally throughout the United States disproportionately against African Americans. So I really question her personally at that level. And I really have to say that that would be something that would be in my mind. And I would be very, very angry about, even though she was very, very competent in what she did, I would still have to personalize this to a certain extent as a defense lawyer and raise some questions about that.
All right, interesting. Matt, what about you?
Well, to be honest, as a former prosecutor, I'm not a big fan of a rebuttal argument. I mean, I believe that you make your case in your closing argument, you lay it out, you argue your points to the jury. But when you come back with rebuttal, sometimes I think it leads to give some credence to the arguments of the defense, because now you're back out there basically trying to refute what they said, almost legitimizing to a certain extent what they said in the eyes of the jurors. Now, some may disagree with that, but I, as a prosecutor in cases that I prosecuted, rarely, if ever, used rebuttal argument. So I think that while her argument was effective, while she was very good and well prepared, I sometimes decline to go in that direction.
All right, well, we're told right now that the jury is deliberating, so we have to take a quick break here on Law and Crime. Stay with us, though. Plenty more when we come back.